So hello everyone, my name is Tushar Rai and today I'll be covering a topic of content of charge and alteration of charge which is mentioned under CRPC. So what is charge? Charge simply means accusation. A charge is a formal recognition of concrete accusations by a magistrate or a court upon a complaint or information against the accused. A charge is drawn up by a court only when the court is satisfied by the prima facie evidence against the accused. The basic idea behind a charge is to make the accused understand what exactly he is accused of so that he can defend himself. And what is the definition? So according to section 2B of CRPC, when a charge contains more than one heads, the head of charges is also a charge. The purpose of framing a charge was mentioned under the case VC Shukla vs State, in which Justice Desai delivering a concurring opined that the purpose of framing a charge is to give intimation to the accused of clear, unambiguous and precise notice of the nature of accusation that the accused is called upon to meet in the course of a trial. So, charge is required to be framed in three types of cases. The first one is session cases under section 228 of CRPC. Second, warrant cases trialable by magistrate instituted by police report under section 240 of CRPC. And third is warrant cases trialable by magistrate instituted otherwise than a police report or instituted on the basis of private complaint under section 246(1) of CRPC directly to the magistrate. So, contents of a charge. Section 211 specifies the contents of a charge as follows: that every charge under this code shall state the offence with which the accused is charged. If the law that creates the offence give it any specific name, the offence may be described in the charge by the name only, example murder, extortion, etc. If the law creates the offence does not give it any specific name, so much of the definition of the offence must be stated as to give the accused notice of the matter in which he is charged. Example under section 184 IPC. So he can be called section 184 or something. And the law and section of the law against which the offence is said to have been committed shall be mentioned in that charge. And the fact that the charge is made is equivalent to a statement that every legal condition required by law to constitute the offence charge was fulfilled in the particular case. If the accused has been previously convicted of any offence, is liable by reason of such previous conviction to enhanced punishment or to punishment of different kinds for a subsequent offence, and it is intended to prove such previous convictions for the purpose of affecting the punishment which the court may think fit to award for the subsequent offences. The fact, date and place of the previous conviction shall be stated in the charge, and if such statement has been omitted, the court may and add it at any time before sentence is passed. And time and place of the offence under section 212. As per section 2121, the charge must also specify the essential facts such as time, place and person comprising the offence. For example, if a person is charged with murder, the charge must specify the name of the victim and date and place of the murder. In case of Shashidhara Kurup vs Union of India 1994 case, no particulars of offence was stated in the charge. It was held that the particulars of offence are required to be stated in the charge so that the accused may take appropriate defence. In case of criminal breach of trust or dishonesty, misappropriation of money or other movable property, it will be enough to specify gross sum or the dates between which the offence was committed is mentioned under section 212 clause 2. The charge so framed shall be deemed as a charge of one offence, section 219, and the time gap between the dates should not exceed 1 year. And manners of committing the offence, section 213. Sometimes even the time and place do not provide sufficient notice of the offence which is a person is charged upon. In such situations, section 213 mandates that the manner in which the offence was made must also be specified in the charge. It says that when the nature of the case is such that the particulars mentioned in the section 211 and 212 do not give accused sufficient notice of the matter with which he is charged, the charge shall also contain such particulars of the manner is which the alleged offence was committed as will be sufficient for the purpose. Section 214-15. Section 214 states that in every charge, words used in describing the offence is deemed to have been used in the sense attached to the offence by law under which the offence is punishable. Section 215 states that for errors in charge, the charge is not deemed to be illegal unless the accused was in fact misled by such error or omission and it has occasioned a failure of justice, which was mentioned in case of Rawalpinta Venkala versus State of Hyderabad 1956. The charge failed to mention the section 34 of IPC, but the description of the offence was mentioned clearly. So SC held that the section number was only of academic significance and the omission was immaterial. Section 216, alteration of charge. First, that any court may alter or add to any charge at any time before judgment is pronounced. Every such alteration or addition shall be read and explained to the accused, not likely to prejudice the accused in his defense or the prosecutor in the conduct of the case. The court may, in its direction or discretion, after such alteration or addition has been made, proceed with the trial as if the altered or added charge has been the original charge. Is likely to prejudice and the accused or the prosecutor, the court may either direct a new trial or adjourn the previous trial for such period as may be necessary. If the offence stated in the altered or added charge is one of the prosecution of which previous sanction is necessary, the case shall not be proceeded until such sanction is obtained, unless sanction has been already obtained for a prosecution on the same facts as those on which altered or added charge is found. Section 217 states, whenever a charge is altered after the commencement of trial, every party shall be allowed to recall or resummon and examine with reference to such change in charge to any witness who may be examined earlier, unless the court records reasons that it was for the purpose of vexation or delay for defeating the end of justice. Call any further witnesses whom the court may think to be material. So that was all from the topic of charge and all the contents and the alterations which have been made in the part of charge on an accused. Thank you.